My name is Bob Aronson. I'm very, very pleased to be co-presenting with my colleague at Fredrikson, Matthew Webster, in this incredibly unusual period of time, talking about healthcare, something which is really at the epicenter of the national dialogue. So I'm hoping that everyone on this call is safe and healthy and doing well. I also want you to know that when I came down this morning dressed in a tie, my granddaughter, who's staying with us, thankfully, burst into tears. She had never seen me in a tie. So I just want you to know at the beginning the sacrifices for the betterment of the community. In terms of housekeeping, let me just say a couple words. In terms of housekeeping, we plan to address questions throughout today's program to the best of our ability. To submit questions, please send them in through the Q&A box, which you should be able to access through the Q&A button at the bottom of your screen. We've enabled the upvoting feature, which means that you can like questions submitted by your fellow listeners so we can tell which questions are the most popular. If you have non-question comments during the program, you can submit them via the chat box. We are recording today's program, and you'll receive an email once the recording has been posted online. So if you're joining us live today, you'll also receive information on continuing education details via email in the next day or so. So with that, let's advance the slides and start into the program. What we're doing today is talking about the intersection of immigration and healthcare. And when we started to formulate this program, Matthew and I had anticipated that our focus would really be exclusively on J-1 waivers. And the reason is that we're entering the time of the year when it becomes very advantageous to solidify your waiver plans in order to file waivers, at least for Conrad, at the very inception of the new waiver cycle, which will start October 1. So that was our initial intention, a J-1 driven program. But since then, there have been just a spate of new developments coming out of Congress, coming out of the medical profession, coming out of U.S. Citizenship and Immigration Services and the Department of State. And we want to take this opportunity to very briefly update you on new developments that we think are extremely germane to your ability to navigate immigration matters to the maximum benefit of your foreign nationals and of your medical systems. And just as a teaser, I could not have scripted this better. About 2 hours ago or so, U.S. Citizenship and Immigration Services, USCIS, released a major new directive, which I'm going to start out with in a second, on IMGs, on international medical graduates, and the maintenance of H-1B status. So we want to talk about really three things: new developments, J-1 waiver practice, and then post-waiver considerations, which is also going to include compliance issues. Okay? So next slide, please. So, learning objectives. We hope that you'll be able to take away from this program an enhanced ability to communicate and support your IMG employees as they come to you or as you need to advise them. What is the scope of options? What are the considerations? How do you balance out compliance with maximum utility to your practice? We want to talk about the J-1 exchange visitor program and the relevance to your IMG community. We definitely want to talk about helpful hints in developing appropriate waiver applications. We want to hit on what happens if your case goes south, what happens if your waiver is denied, what are your options, and then we want to talk, and in a way this is going to be the bookend on compliance issues. What happens under changed circumstances in order to maintain H-1B status? So next slide, please. I'm going to ad-lib on a new development that was released by USCIS quite recently. Recently being, we think, I don't have an exact time, but we think it's within the past 2 hours or so. A core principle of H-1B status is the need to, and waiver for that matter, the need to submit to the USCIS or the state a complete description of the duties, responsibilities, the job description of a physician, what they're being paid, what their hours are, what their status of employment. It's a complete litany of a description of the job. USCIS gets that holistic description, and if they feel that it meets H-1B standards, they approve the case. And under traditional H-1B practice, an employer and a foreign national are locked into that job description. So you're locked into where the physician is working, how much they're getting paid, what their hours are, what their practice area, and so on. And usually that works pretty well. It's a good bargain between what you've represented and your obligations to comply. Well, then the COVID crisis came, and we're seeing an incredible upheaval within the healthcare community. So the issue becomes, to what degree is there flexibility when an employer needs to readjust hours, readjust wages, readjust practice sites to a physician? The traditional answer is you can't do it without either amending the petition or violating a key principle of H-1B. Well, USCIS has now issued a policy memo that is specifically related to physicians holding J-1 waivers. And it finally injects a level of flexibility into the process. And it says the following, that if you are employing an H-1B physician who becomes temporarily unable to work due to quarantine, illness, travel restrictions, and here's the kicker, or other consequences of the pandemic, which could be strains on a healthcare system during the public health emergency period, that USCIS will not consider the failure to work full-time to be violative of H-1B status. That's the first provision. Second provision of the USCIS policy is that if a physician is employed by or has received a waiver from a government agency or from a State Department of Health, that the physician is now empowered to or authorized to provide telemedicine without violating status. So there's going to be no need to post. There's going to be no need to go through any type of amendment or risk of a violation if the physician within the same geographic area is now working out of home. And thirdly, that if there is any lapse in full-time employment related to COVID-19 that occurred during the period starting January 27th through the end of the public health emergency, that telehealth services will be effective and not violative of H-1B status. the implications here really are immense in terms of relieving exposure from IMGs and allowing healthcare systems to better utilize physicians for the betterment of their systems. So we're going to get back to this, but this is literally, this happened today. So we can talk about this and explore it further. But we also wanted to go through just very briefly a couple new developments that pertain to J-1 physicians in the effort to maximize their benefit to the U.S. healthcare system. Matthew? So you have, and I'm sure you've been hearing from your physicians, that there's a proposal in the Senate. There is the expectation the House is going to follow suit, which will inject 40,000 green card numbers into the U.S. immigration system, and of that amount, 15,000 are intended to be used exclusively for physicians. And the goal is to, realistically, is to clear up or at least substantially reduce the backlog and waiting time for Indian physicians. Right now, an Indian physician is generally looking at a 10+ year waiting period to get a green card. And the belief is that there's somewhere between 13,000 and 20,000 Indian physicians in the queue to get their green card. So 15,000 green card numbers or immigrant visa numbers would substantially reduce that backlog. And in so doing, the Healthcare Workforce Resilience Act removes the current limitation in the U.S. immigration system that restricts to 7% any single country that can get green cards. So, and this bill also requires cases for physicians to be premium processed. Premium processed in terms of the adjustment of status, in terms of the adjudication of the immigrant visa petition, and in terms of consular processing. So again, this is a proposal. It was just introduced last week. Physicians, particularly your Indian physicians, have seized on this as being a light in an otherwise bleak environment, and they're all over this proposal. I think that there probably will be something passed, whether it's along the Perdue-Durbin lines or will have some significant variances. That's still to be seen. Next slide, please. The House has yet to act. There is a declaration that the House intends to introduce companion legislation to Perdue-Durbin. In addition, there seems to be a growing movement to go a little bit beyond the Perdue-Durbin proposal and to increase Conrad numbers, to expand recognition of when a case qualifies for physician national interest waiver, which is the program leading, it's a streamlined program leading to permanent residence, but it does require a 5-year period of commitment to medically underserved areas. And it makes available immigrant visa numbers to an expanded number of international medical graduates, in particular those treating COVID or working in medically underserved areas. There has been pending in the Senate, and there appears to be some resurgence of interest, a bill which is actually sponsored by Senator Klobuchar from Minnesota, my home state. We've been working with her office on this bill, which would make the Conrad program permanent. It would have triggers to increase the allotment of J-1 waiver numbers, which are currently capped at 30 waiver numbers per state. It would recognize that academic medical centers serve as important safety net providers to the general population, thereby making academic medical centers eligible for J-1 waiver consideration. It expands, it provides to dependent spouses work authorization, which would be of immense importance in terms of promoting job stability particularly within isolated and rural communities. And it also provides provisions allowing for greater mobility to change employment. So this is the most comprehensive bill related to J-1 physicians. Parallel to all of this, the Department of Health and Human Services, which is tasked with promoting healthcare safety and policies within the United States, has maintained a highly restricted J-1 waiver program. And the advantage to the federal agency, to the Department of Health and Human Services, is there is no numerical limitation. So you're not in a horse race for a limited number of waiver numbers. The problem historically with the Department of Health and Human Service clinical waiver program is it has been so highly restricted. It basically said that one of the prerequisites for J-1 waiver eligibility is that the applying employer needs to be an FQHC, a federally qualified health center, or a rural health center, or an IHS, an Indian Health Service center. That has now been, as of about 2 weeks ago, that has been eliminated. So you have now the Department of Health and Human Services will serve as an interested government agency. It will serve as a waiver sponsor, but the basic requirements would be that the physician be practicing primary care and trained solely as primary care and working in a placement site holding a score of HPSA 7 or above. But again, the elimination of the facility restriction is a major, major step forward. The last thing I want to say is that we're seeing, as you know, significant restrictions in U.S. immigration law and policy. And they're really focused on travel restrictions, eligibility for visa appointments, new restrictions primarily for foreign nationals coming from abroad under the executive order, intended to get intended to get permanent residence. There is a growing movement to link the expanding number of the unemployed as a causality to restrict immigration to the United States. Thus far, healthcare workers, physicians have been largely excluded from those restrictions, largely. One element of concern, though, is that there was that in the President's executive order of April 22nd, there is a 60-day period allocated to assess how things are going and to take measures intended to modulate immigration in light of the COVID crisis. Well, 4 senators, Senator Grassley, Senator Cotton, Senator Cruz, and I can't remember the 4th, has written a letter saying, look, because of the expansion in the increase in unemployment, we really need to staunch immigration. We really need to prohibit new non-immigrant visas. We really need to put the kibosh on OPT. It's really a draconian measure. There's no carve out in that letter for healthcare workers. Again, flagging it, this is something which is floating. I hope and pray this will not transform itself into U.S. policy, but it's something just to be aware of. Okay, So this is a smorgasbord of new developments coming out of Congress, coming out of the agencies, and so on. And with that, I'd like to turn the program over to Matthew to really kind of get to exchange visitor. And our goal is to provide some basics to the program, and so we have a common foundation, but then to really talk about how do you best prepare a J-1 waiver application. So Matthew?
Absolutely. Thank you, Bob. It's my pleasure to get to speak with Bob today on the J-1 program specifically and looking at the different waivers available, and then some different strategies for you as healthcare institutions to really recruit these individuals and kind of maximize your healthcare coverage. So just to begin, we want to just kind of set the stage as to what a J-1 program is, the impact on physicians, and then the various waivers and strategies for moving forward for those individuals to continue practicing here and to really base their practice here in the United States. So the J-1 program is a pretty extensive program that includes a lot more than just physicians. If you've ever gone up to northern Minnesota and gone to any of the resorts or gone to Door County and seen the orchards there, many of those resort areas are hiring J-1 workers. So the J-1 program includes things such as au pairs, summer interns, high school exchanges, Fulbright scholar programs, and other university exchanges, in addition to the physicians. And while our program today will obviously focus on the physician aspect, it does bear mentioning this is a really widely used program. As of last year, there were 300,000 J-1 foreign visitors from over 200 countries. So it's a really heavily utilized program that's administered by the Department of State. For example, here in Minnesota, we had 47 J-1 physicians in the state that entered in 2019. In terms of why physicians are subject to the J-1 program, and specifically why they're subject to the 2-year waiver, there's an idea that this is an exchange program versus just an educational program. So the idea being that these physicians would come here for their residency, for their fellowship, and then they would bring that information and that knowledge base back to their home countries. So you can see kind of why the Department of State is interested here and how it's kind of used diplomatically as an ambassadorial program. So these individuals are getting education here and then going back to their home countries to kind of bring that and obviously kind of preach the U.S. healthcare system and the training they got here, but then be able to apply that in their home countries. And we'll talk about the 2-year home residence requirement, but that's kind of embedded in why physicians are housed within the J-1 program versus, for example, the F-1 program, which is strictly an educational program. As I mentioned before, the Department of State is involved in the J-1 program in kind of all of the various programs administered under the J-1, as well as physicians. So here, the Department of State authorizes the Educational Commission for Foreign Medical Graduates to authorize foreign medical graduates to come to the United States to conduct their medical training, their residencies, their fellowships, their internships. So it's kind of a partnership of those two. In terms of what the foreign medical graduates need to satisfy in order to qualify for the program, the individuals have to pass their USMLE steps. They need to hold an ECFMG certificate unless they're from Canada. They need to hold an offer letter or a contract from the institution where they will be placed. And then they also need to provide a statement of need. So all of that is kind of done on the front end through ECFMG, which is authorized by the Department of State. Moving on to the final piece here, the time for the program is set through the American Board of Medical Specialties, and it really depends on the specialty that the individual is engaged in. They're limited to the time typically required to complete that program, and in no instance can it exceed a 7-year period. Another important limitation to the J-1 program is it does not allow for any moonlighting. So the individual is really limited to work within their specific training program. So as I mentioned before, the J-1 program does have certain specific limitations embedded within it. And this is the most pertinent one for foreign medical graduates, for physicians that are here in the United States. There is blanket coverage for all J-1 clinical trainees that they need to return to their home country for a 2-year term before they can change status to that of H-1B, which is kind of your standard employment status within the United States, or before they apply for permanent residence to become a green card holder in the U.S. And that is true across the board for all J-1 clinical trainees. The individual actually needs to go back to their home country. They can't go to a third country. They need to satisfy that 2-year home residence requirement. It can be cumulative or in the aggregate, but they do actually need to satisfy that 2-year home residence requirement unless they receive a waiver of that requirement. As I mentioned, the individuals are ineligible to either adjust to lawful permanent resident status unless they fulfill that home residence requirement or get a waiver, or to change status to that of an H-1B status. But it doesn't disqualify them from eligibility for other non-immigrant visas, one of the most pertinent of which is an O-1. So oftentimes, if an individual is unable to get a waiver and does not want to go to their home country, they can apply for another status in the interim, such as an O-1. Before I move on, I also want to note that that 2-year home residence requirement also applies to the J-1 dependents. So their spouse and their children that are in J-2 status, they also have a requirement to go home for the 2 years or to get a waiver of that 2-year home residence requirement. So again, the options once an individual is done with their necessary medical training is either return home for the 2 years to satisfy that requirement, after which they can come back and seek H-1B status or permanent residence. They can obtain a waiver, which the rest of our discussion today will focus on, or they can qualify for some alternative visa status, like an O-1, or in some cases an F-1. So now we'll move on to the specific waivers available for foreign medical graduates. We'll talk briefly about some of the other ones before we move on to the government agency sponsorship, which is really the most relevant here and the most utilized. A J-1 physician could qualify for a waiver of that 2-year home residence requirement if they can establish exceptional hardship to an anchor relative. Here, that is really circumscribed, and that anchor relative would have to be a U.S. citizen spouse or a lawful permanent resident spouse or a U.S. citizen or lawful permanent resident child. So it's pretty limited, and you would have to establish that there would be exceptional hardship. So in some cases, medical care or education for an individual that wouldn't be able to get that in their home country. But it's a pretty limited waiver possibility for a J-1 physician. Another potential waiver is a persecution waiver. If any of you are familiar with asylum, it tracks the asylum analysis, although it is more limited than asylum in many respects. And so this is a pretty underutilized waiver because the asylum process is actually more straightforward. And so most individuals, if they were seeking to establish a persecution waiver, would just simply apply for asylum. The standards are better for asylum. The categories are more narrow for the persecution waiver. Really, the one redeeming aspect is that an individual can file it beyond the 1-year filing deadline for asylum applications. Again, the rest of our conversation today will really focus on the various government agency waivers that can be sponsored by those government agencies. So one is a federal employer, such as the VA or the U.S. Army. Other government agencies could be an interested federal agency, like the Delta Regional Commission, the Appalachian Regional Commission, or Health and Human Services. Bob mentioned the HHS waivers earlier. Another potential waiver through a government agency would be if an individual is conducting research of national importance, That could be sponsored either by Health and Human Services or the NIH program, the National Institutes of Health. The last piece here is what we'll talk about for the next couple slides, and that is the Conrad State 30 Waiver Program. So each individual state Department of Health has 30 potential waivers that they can use to provide necessary medical coverage for the medically underserved and the indigent in their states. Oftentimes these are really focused on rural or medically underserved within urban areas. One waiver that is specifically not available for J-1 physicians is a release from their home country or a no objection statement from their home country. This is available for other J-1 programs, but in the case of foreign medical graduates, it is not available. So we're really looking at the exceptional hardship, persecution, and government agency sponsorship when we're thinking about waivers for that 2-year home residence requirement. So the Conrad State 30 Waiver Program allows each state's Department of Health to recommend up to 30 physicians a year who will serve their specific public interest of that state. Again, this is really based on a public policy decision to expand the safety net, again, covering the medically underserved and really tailored to that state's needs. It's a federal-state partnership, so the federal government in the regulations here kind of sets the overview for the program, and then each state adopts their own specific criteria for their Conrad 30 program. So the federal program really just requires 3 things. One is that the individual is signatory to a bona fide full-time employment contract in H-1B status for 3 years in a HPSA or an MUA, MUP, or serving those patients. That the second criteria is that there's a no objection statement issued by the home country if the individual is contractually obligated to return to their home country. And then third, that the individual physician agrees to begin their work within 90 days of receipt of the waiver. And the key there is that they agree to begin. Oftentimes that's not possible. The waiver gets issued and then the H-1B sometimes takes longer than that. Sometimes the waiver gets issued well in advance of the end of that person's program. And so as long as the individual agrees to begin employment at the facility within that 90-day period, we haven't seen any issues with that. It's kind of a creature of the specific wording of the regulation. Beyond the federal 3 criteria, each state then adopts its own criteria, and those really vary quite widely. The states fill in the blanks and really tailor the program to the needs of their state. So there are some states that are really circumscribed. Connecticut, for example, they really specify even the types of specialties that will qualify that they accept. So they'll accept, say, 2 gastroenterologists or 1 of this. Other states take a much more laissez-faire and really accept all applicants, all specialties. Obviously here, the focus for most states is primary care, and again, meeting the needs of the medically underserved and indigent. But the way that each state effectuates the waiver program really differs quite widely.
Matthew, pardon me 1 second. I think your system may be frozen in terms of advancing the slides. So I just want to, well, maybe not. Okay, sorry.
No worries. Thank you, Bob.
Okay.
So again, the federal requirements, we talked about those 3 criteria. The federal requirements do limit each state to 30 waivers. So as Bob mentioned, there's some traction for potentially getting beyond 30 waivers each fiscal year, but at this time, and since the beginning of the program, it's really been limited to those 30 waivers. States can have up to 10 flex waivers, and flex waivers enable a state to place individuals within areas that are not a HPSA designated area or a medically underserved area, an MUA area, but that are instead meeting the needs of patients hailing from those areas. So if you think about many urban areas in the country, they might not necessarily qualify as a HPSA designated area or a MUA area, but they are primarily meeting the needs of the medically underserved coming from those areas. And so states can have up to 10 flex waivers for individuals placed in areas that are not HPSA designated. And then the rest are just kind of normal, straightforward Conrad waivers where individuals are placed in medically underserved placements. Again, there's a 3-year employment obligation. So the J-1 physicians are placed with this employer for a 3-year period at the work sites listed. And the individual needs to agree again within 90 days to begin their work. So we've kind of covered the overview of what the J-1 program is, the home residence requirement, and then the specific waivers available. And we've delved into the federal requirements and the state requirements for those J-1 waiver programs. Now we'll talk about some areas for state policy and variation. And just as a brief kind of overview, this really varies significantly from state to state. Again, some states fill up on the first day that the waivers are available. Some states, for example, New Mexico, begin their process on September 1st, whereas the fiscal year really begins October 1st. So there's differences in timing, there's differences in their priorities, and there's differences in the documentation that they require. So it's really important to plan strategically well in advance because these are quite sought after waivers and each state does vary. So one key area of state policy and variation is their emphasis on primary care versus specialty care. Some states really prioritize primary care and only allow a few specialty placements. Some, again, are much more wide open. Some states only accept primary care up to a certain date, say December 31st, and then on January 1st, if there are still numbers available, we'll open it up to specialties. So it really varies, really depending on the utilization of those 30 waiver numbers within that state, and then also really the specific needs of that state. As you all know, primary care is really sought after and is really needed everywhere, but there are some areas where specialties are really lacking, and so that might be the best placement for that state's Department of Health to really meet that specialty gap that they are experiencing in their state. So again, it varies quite significantly from state to state. States also have different definitions of what they consider primary care, and so it again varies from state to state. And so strategically, if you're looking at a state that has very limited specialty placements, you want to carefully look at the state's definition of primary care to ensure that it includes the individuals you're looking for beyond those specialties. Another area of state variation and deviation are the limitations on the underserved designation. So some states require certain HPSA scores for those areas. Some states prioritize higher HPSA scores. So as we'll talk about a little later, it's more merit-based, and so they look at, a HPSA 17 is going to be given higher priority than a facility that is in a HPSA 7, for example. So that's some way in which states vary. Some states don't have any limitations on the specifics of the healthcare facilities. There's also limitations for employers. Some states limit an employer to placing a Conrad physician at a single work site. Some specifically define full-time work as 40 hours of direct care. Some define it as 32 hours of direct care plus consultations. So there is some specific limitations that certain states place on employers. There's also certain flex policies. Like I said, states are given 10. Some utilize all of those. Some utilize less of them. Some open up the flex spots if the 30 numbers waiver slots have not been used by January 1st or by some date certain. States also vary in whether or not they permit an employer to have an employment agreement with either a non-compete or liquidated damages provision. Some states outright prohibit this. Some states are silent on this. So again, this is important as you're negotiating and drafting those contracts. It's important to know your state's specific requirements for the J-1 waiver physician. Some states impose strict reporting requirements, reporting requirements that a physician report as soon as they begin their work at the facility. Some have periodic ongoing reporting requirements, say at 6-month intervals, and some have reporting requirements once an individual finishes the program or otherwise departs the program. Some states have application fees. I'd say most states don't, but some have quite significant application fees. Illinois, for example, I believe is $3,000. So it does vary significantly from state to state. And then, as I mentioned before, the states really have wide variation in the way that they adjudicate and accept J-1 Conrad waivers. So some states are really merit-based. They will, again, prioritize specific specialty areas, specific primary care areas, and assess it based on the merits of the petitions rather than on when the petitions were filed. Some are first in, first out. So the state will accept applications until they fill those 30 slots and then will not consider any more, notwithstanding the merits of those additional waiver applications. And then some are a combination of both, where they will accept applications for, say, a month or 2, and then they'll do a merit-based analysis of that. Again, as I mentioned, some states give priority to certain HPSA scores over others. Some states give certain priorities to certain specialties or certain areas that the state has determined are really in need within that area. So those are really some of the strategic determinations that employers should be making when they're considering hiring a J-1 waiver physician and sponsoring them for one of these Conrad 30 waivers. There are significant things to be thinking about at the outset as you're negotiating with the physician and as you're strategizing getting them hired and into one of these waiver slots within your specific state. Now we'll turn it over to you, Bob.
Okay, we've got 15 minutes left, and I want to do 3 things, and this is going to be a little bit of buckle up and let's go real quickly. I want to talk about optimizing a successful waiver, number 1. Number 2, what happens if a waiver is denied? And then number 3, I want to get back to this notion of flexibility in H-1B employment. So we've listed out what we think are 10 keys to a successful J-1 waiver case. The biggest thing, which I think employers and their advisors need to be aware, is that you've got to, or in most cases, many cases, you really need to shift your recruitment timeline. So you kind of need, for a J-1 recruitment, you need to be interviewing and the employer needs to be interviewing and considering a J-1 applicant really starting in the summer, literally a year in advance. So the normal kind of recruitment timeline would have probably employment offers going out in midwinter for a start date in July, August. You don't have that in many instances, that luxury. You need to make decisions kind of in June, July, August latest. Why? The whole idea is to file your waiver application on day number 1, and when the state opens up its waiver program to new applications, because all I know as a practitioner is that at midnight, each state has, of the first day of October 1, the state has 30 waiver numbers. What I don't know is how many applications are going to be received, and therefore there's a huge, you're going to optimize your chances by filing early. It obviously is going to make some sense to understand the state's historical utilization patterns, but that comes with a caveat. And what we're seeing, and here's my theory, we're seeing an abnormally heavy drawdown on J-1 waiver numbers early in the waiver cycle. I mean, states are filling up their 30 waiver slots much, much earlier than they did 1, 2, and 3 years ago. And I think the reason is that physicians are so destabilized that they are taking the first job that comes along with the idea of maximizing their waiver chances. They're no longer holding out for the best job offer. They're kind of taking the first offer that comes along. And I think that's a big reason why we're seeing this early drawdown on waiver numbers. So what I want to convey is, yes, it's important to understand the state's historical utilization patterns, but I don't think you can rely on that to the level of certainty as you once did. We find that J-1 waiver officers are really accessible. They want the program to work. This is a great healthcare planning tool to get physicians into hard-to-fill placements, and we maintain great relationships with most of the waiver officers because there's kind of a commonality of interest. What I'd like you to be aware of, and obviously we'd hope that you would use us, but whoever you're using is you should be involving your immigration attorney during the recruitment process. Have your immigration attorney speaking with your candidates, explaining what can and cannot be done, what needs to be done. Convey a sense of commitment and purpose to getting a waiver. So this is quite important to look at the immigration attorney kind of as a supplement to your marketing program. But then once the recruitment offer has been made, your immigration attorney really needs to orchestrate the case and understand the federal law, the state guidelines, timelines, and so on. The one thing which I would like to just kind of emphasize, the whole purpose of the J-1 waiver program is to expand the safety net, to get physicians into hard-to-fill placements, to have them serve medically underserved patients, minority, indigent, and so on. So we always want to include a lot of metrics. What's the demographics of a given, what's the metrics of a given healthcare provider? That is, what's the level of public, of Medicaid, Medicare, public assistance, minority, and so on. Okay, let's go on if we can. Okay, so if the waiver is, this is a real quickie. If the waiver is recommended, then it goes to Department of State, it goes to USCIS, they have to verify, but frankly, there's not any case I'm aware of in which the federal authorities have overridden the decision of the state. And then you have to file the H-1B, and the physician needs to work 3 years in H-1B. Next slide, please. Here's what I want to spend just a little bit of time. If you get a denial, you obviously can simply say that's the end of the story. And it may be, but I think that it makes sense to still assess what the system's interest in the physician is, and if there may be any wiggle room to get the physician on board. And analytically, you want to divide up denied applicants into Canadians and all others. And here's the reason. The 2-year home residence obligation makes a foreign national, in our case, a physician, ineligible for an H-1B visa. Well, Canadians are the only nationality in the world that are visa exempt. Canadians don't have to go to a U.S. consulate, get a stamp on their passport in order to come into the United States. Rather, they show up at a port of entry and present the grounds for eligibility to enter the United States, and they are admitted. It's visa exempt. So there was a court case, which I've identified here just because it's so salient, which says that even if a Canadian is subject to the 2-year home residence obligation, they are still eligible for H-1B because all they require is H-1B status, not an H-1B visa. They still need a waiver in order to get permanent residence, but they at least they're H-1B eligible. That does not get you out of the woods, though, because you still need to develop with normal, you still need to handle and address normal H-1B practice. And that leads into issues of the H-1B cap, that limitation to 65,000 H-1B visa numbers when you have a system in which normally there's literally 200,000 or so H-1B petitions filed in any given year. So either the Canadian physician needs to go through the cap, the lottery system, or you can try to position a case for H-1B cap exemption. So if the employer is a university or a nonprofit affiliated institution, i.e. teaching hospital, they would be exempt. Or if you can arrange that the placement, at least in part, will take place on the premises of a cap exempt entity, like a teaching hospital, like a university, that in turn could lead to an exemption by the H-1B employer. Or if you can split things where at least part of the employment is done by a university or a cap exempt entity, and the other part by the normal employer, that would also move a case into cap exemption. My only point is you want to go through a rigorous analysis for the benefit of the employer. And also, you know, this may not be the end of the story. You still need to get a waiver ultimately in order for the physician to get permanent residence. But if it's Canadian, you still may have a shot at H-1B employment. Okay, next slide. If a denial comes and Canadian or all others, what are your options? Again, they're fairly limited, but let's go through them. The big one is, would the physician be eligible for an O-1 visa? That is a temporary non-immigrant visa status, and it says that the physician possesses extraordinary abilities. It's a high standard, but again, the 2-year home residence obligation pertains to H-1B and permanent residence. It does not pertain to O-1. And Matthew had talked about that a little bit. There may be some other opportunities, mainly F1. Again, it's not going to happen a whole lot, but again, it's possible. In some cases, maybe the physician would extend to become a chief resident, if possible, to at least get status for another year, to go back into the waiver process after another year. We would always look at the spousal situation. There is a chance that that the spouse may be in J-1. The rejected J-1 physician could go into J-2 and apply for employment authorization. And then, of course, there's asylum or TPS. Again, this is all highly case-specific, but it is something to be examined. Okay, the last thing I want to talk about is compliance issues. And over the past period of time, over the past 8 weeks, we have been dealing with just a barrage of questions from employers, from foreign nationals who, again, want to maintain H-1B status, compliance, and yet are faced with major hurdles, major barriers arising from the COVID crisis. So it is issues connected with, can they assign physicians to telemedicine, working out of the home? Can they assign physicians to different facilities? Can they put a physician into part-time employment? Can they readjust the wages? And again, the basic rule has been the H-1B needs, what has been represented to the government needs to be honored. The only essential ground is if an H-1B foreign national comes to the employer and says that they, for their own benefit, want to go on, let's say, unpaid leave. The paradigm is parental leave. So can you squeeze a reduction of hours into a request coming out of the foreign national. That's thin ice. That's thin ice. But what you do have is this new directive from USCIS, which starts to recognize that there has to be flexibility, particularly in J-1 physicians with J-1 waivers. They've already demonstrated that their presence in the United States is of service to the public good, the national benefit. And so why limit them, given the exigencies of the current situation, to the to exactly what is said? And that's what the directive, which was issued today, seeks to establish, to create at least some recognition that there has to be flexibility given the current situation. Here's what we don't know. And again, the policy memo just came out, and we'll try to keep you updated. So if a physician and if an employer wants to take advantage of the flexibility provisions, what do they have to do? What do they have to communicate? So first of all, there is a recognition you can have flexibility for other consequences of the pandemic. What does that mean? I would think that would include contraction or restructuring of an employer, a need to put a physician on part-time, or a suspension of elective services. In my opinion, that would fall into a situation justifying flexibility, but we don't know yet. Number two, do you need to report to immigration? Do you need to register that you're going part-time? Or is this something that you address at the time that a physician adjusts to permanent resident status? So these are all issues yet to be resolved. In terms of furlough, I would say that would also fall within the flexibility provisions. But in terms of termination, just remember one thing, and that is H-1B. If you need to terminate a physician, that is the right of an employer. H-1B is not a contractual relationship. It gives an employer the right to terminate, and the physician, the H-1B, would then get up to 60 days of extended H-1B status. We can go, time is up. This is obviously just a roiling area of change, but we very much appreciated the opportunity to speak with you, to start exploring some things, and we hope to be active and informed and responsible providers of information. My dear and esteemed, go ahead.
Oh, sorry. I was just going to say we did get one question.
I know.
I just want to follow up regarding unpaid leave, whether this new pronouncement has changed physicians' ability to request unpaid leave.
And the question is posed by my very, very dear friend and very esteemed colleague, Jen Bianco out of Cleveland. No, if I did say that, unpaid leave, I would say, would, particularly in the flexibility provisions, would be allowed. And look, unpaid leave is going to come up in two situations. Number one, at the instigation of the H-1B employee, and that would certainly be allowed if someone needs time off to care for someone or is suffering from COVID, him or herself, or so on. What I think that what the USCIS directive states is that there's enhanced ability for unpaid leaves. That's the furlough type of situation where someone is still considered to be an employee, but owing to needs of the employer and the general situation, there's going to be a hiatus in payment. I think that is falling within the flexibility provisions. So with that, I hope this has been a useful expenditure of your time. It's been a great pleasure. and I think I can speak in conjunction with Matthew, to have had the opportunity to speak with you. And I hope that we kind of moved the ball in terms of your understanding and both of your opportunities and responsibilities. And again, this is a changing environment, and we definitely hope to be providers of information and guidance as we move forward. So with that, thank you and enjoy the day and stay safe.
Thank you all.
Bye-bye.